The day my brother shook hands with the man who was buying our company, he looked at me across the conference table and smiled. Not the kind of smile that says we made it, the kind that says I already did. I didn't understand it then. I told myself I was reading too much into things. That's what you do when you love someone. You give them the benefit of the doubt. But by the time the doubt wins, you've already lost everything. My name isn't important. What happened to me is I grew up in Columbus, Ohio, middle class but barely. I watched my father be decent his entire life, and I watched decency fail him. He got laid off 6 months before his pension vested. That detail shaped everything about how I moved through the world. So I became obsessed with building something that couldn't be taken away, something real. In 2011, Daniel called me from Denver, where he'd been living since his divorce. He had an idea: a logistics coordination software for small freight carriers, companies too small for enterprise systems but too complex for spreadsheets. He had the vision, I had the financial and operational knowledge. Between us, we had something real. We each put in $40,000, everything we had. I liquidated my account. He borrowed against his truck. We called it Viridian Freight Solutions. The first 2 years were brutal in the way that any honest startup is brutal. We shared an apartment to cut costs. By 2016, we had 211 clients. By 2018, Viridian was generating $4.2 million in recurring revenue. We were legitimate. We were real. And for the first time, I felt like my father's story wasn't going to be my story. The first sign came in March of 2019, and I almost missed it. I noticed a recurring charge to an LLC I didn't recognize, Talbert Advisory Group, $11,000 a month. Daniel told me it was a growth consultant. He said it like it was nothing. I let it go. I shouldn't have let it go. Talbert wasn't a growth consultant. They were buy-side M&A intermediaries. My brother had been quietly preparing Viridian for sale without telling me. But that wasn't the part that destroyed me. To understand the weight of what happened next, you have to understand our shareholder agreement. A drag-along provision: if a shareholder representing more than 40% of equity agreed to a sale, the other founder could be dragged along. I had signed that document. My signature was on every page. I just hadn't understood what I was signing. It was a Friday afternoon. I was in the break room refilling a coffee cup. Kristen walked past and said without stopping, "You excited about Nashville?" I said, "What?" I walked directly to Daniel's office. He looked at me and said, these were his exact words, the words I will hear for the rest of my life: "I was going to tell you this weekend." I sat down across from him. I felt strangely calm. I said, "Oh, how long?" He said, "We started conversations in April." It was October. He didn't say anything. He walked me through it. 31 million for the whole company, a life-changing number. My stake would net me approximately 14 million. But he had negotiated an additional $2.1 million in a founder management premium, a number that would come directly off the top before the equity split. He had arranged for everyone. That night, I drove home and sat in my car for 45 minutes. What I felt was a very specific kind of grief for the version of my brother I had believed in for 38 years. That version was dead. I called a corporate attorney that Saturday morning, a woman named Donna Castillo in Columbus who specialized in shareholder disputes. She was exceptionally precise and completely unsentimental. She called me Sunday afternoon. She said, "The drag-along provision is enforceable. The board vote was technically valid. The deal can close." I said, "So that's it?" She said, "I didn't say that." The management premium was Daniel's mistake. Don identified it within 48 hours. Under our agreement, any premium above a certain threshold required the written consent of both founders. Daniel had not sought my consent. Donna said we had a claim, a real one, enough to claw back the premium plus damages for the breach of fiduciary duty. She estimated exposure between 2.5 and 4 million. I told her to file. The lawsuit was necessary. It was what created the first crack in the transaction timeline. I was going to protect my legal rights. The litigation surfaced the Talbert invoices in discovery, $132,000 in consulting fees paid to Weller's firm without my knowledge. Dana's team argued these were unauthorized expenditures for Daniel's personal benefit. Second, it put Gary Allison under deposition. Gary was not a sophisticated man under pressure. When asked about his relationship with Daniel, he was evasive in ways that made him look worse than the facts required. Depositions have a way of revealing character. Gary's character under cross-examination was not impressive. Third, and this became the most significant, a trade publication ran a brief item about the pending litigation. It was 12 sentences. It was shared 300 times in industry groups. And 2 of Viridian's top 10 clients called me directly to ask what was happening. I had built those relationships, and they deserved honesty. The litigation settled in February of 2020. After taxes and fees, I walked away with $15.4 million. Daniel walked away with $12.9. That precise inversion of the outcome he engineered mattered. The closing happened via DocuSign. Daniel sent me a text on the day it finalized. It said, "It's done." I didn't respond. My mother called that evening. She hoped we could repair things, saying family was more important than business. I said, "I agree completely." Then I hung up. The revenge arc, the settlement, the financial outcome, those things have a finish line. What I was unprepared for was the audit, not a financial one, a personal one. I spent the better part of 2020 going back through everything, every decision, every moment where I had noticed something and explained it away. The Talbert invoice, the attorney recommendation. I realized I had made it easy for him. Not because I was naive, but because I had conflated love with trust, and they are not the same thing. In June of 2020, I registered a new company. I called it Meridian Operational Technologies. Same sector, different architecture. I knew exactly where the product needed to evolve. I reached out to the 3 clients who had told me they'd follow me. All 3 signed letters of intent within 60 days. I brought in 2 engineers from the original team who Daniel had overlooked. I funded it myself. No outside investors, no advisory boards, no partners, just me. The first time you're trying to survive, the second time you're trying to do it right. I moved differently, slower in some ways, faster in others. I was precise about the contracts I signed. I read every document myself. I hired my own attorney, someone I vetted independently. I structured the company so that no operational or financial decision of consequence could ever be taken away again. I learned the difference between love and trust, and I'm never making that mistake again.